All right, people, let's begin. So, Article 8 to 11, if you want to understand why these articles are all placed in the same category of application, or rather how you use it formally, is because they all share the same shape of having point 1 and point 2 parts, meaning you have Article 8.1 and Article 8.2, 9.1, 9.2, and so on. And pretty much the only thing you need to know about that is that Article 1 is more about what type of rights, point 1 is more about the rights in itself, of what it is, and then point 2 is going to be the limitation of said rights. Now, how these ideas manifest, you'd say probably from Article 8 to 11, excluding Article 9 about freedom of religion. Everything in the first point of each article is immutable. Meaning, for instance, Article 8 on private life, point 1, so 8.1 protects the right. 8.2 will always give a list of ways you can limit all of these rights. And then with Article 9, as you will see in the later videos, the reason that it's a bit different from the others is because it's partly in Article 9.1 about absolute right to religious freedom, which is both then being of a part of a religion and being a believer, but then also the right to be a believer amongst other believers of the same religion. These two aspects are absolutely protected. But then there are manifestations outside of religious contexts. For instance, a manifestation could be by speech, it could be by symbol, aka then maybe wearing a cross, hijab, so on. Those are parts which are immutable. Then Article 10, same thing, you have 10.1 protecting the freedom of speech, and then point 10.2, which prohibits speech. And then 11, I'm drawing a blank. I think it's the right to gather and associate and so on. Those type of rights can be limited through then. So you have first 10.1, which gives you the right to be part of a demonstration and be associated with one. And then 10.2 gives away a few limitations. However, there are certain aspects, such as the limitation of a non-violent demonstration it's still technically relative, but it's very, very limited in how much of a margin of appreciation a state can be given by the court and how they would like to limit these things. Now I've just gone through real quick what 8 to 11 is, just so anyone watching this, because you'll have to start with this video, doesn't get confused about how I'm explaining my examples. I will be very general about this explanation. I will go through every article one-on-one in separate videos. So no court law, no looking through specific things. We're just going to look at the systematics of limiting these rights, but also just how these rights should manifest in societies, or rather states that are part of the convention. So, first of all, these articles are where margin of appreciation becomes the most effective. In the coming videos, we're going to discuss very, very interesting cases of different nations having different ideas. I find it very interesting. I find it very fun. I find it more rewarding than looking at the EU, for instance. The EU is more about sort of separating nationalism, except for the context of directives, but that's for another video, or decisions as well. Anyways, we're on the convention. Margin of appreciation, it's going to be a big part of this. For instance, with Article 2 to 3 about the right to life and the right to not be tortured and not be enslaved, those type of things doesn't really make sense where that margin of appreciation sort of has a big part in it. It used to, right after World War II. For instance, the right to life was more limited and therefore more applicable to the margin of appreciation. However, it's not today. 8 to 11 is where you find the most cases of this. However, it's not exclusive and it's not exhaustive either. Moving on. So there are 4 steps. I've separated the steps. I have one part of the steps which is just like a real quick part, like just going through it, and then I have another iteration of the same steps, but with a little further explanation. So let's just look through everything at once. Starting with the short steps, admissibility is the first one, of asking if Article 8 to 11 is valid in a case of where an applicant wants to read out their rights or scream out their rights, whatever, just, bring it to the court. Then if admissibility is okay, if it's not, then it's done. It's not going to happen, no court, whatever. But if we get to point 2 of admissibility, meaning did it fall into the article, then, well, yeah, I should also add, step 1 is about the point 1 of each article. So how you know if something is admissible is by seeing if these rights are even protected to begin with. It's important to remember, one of the main principles of Rechtsstat, or rule of law, or Rechtsstat, is that these ideas of what is protected and what isn't is built upon the presumption of a state having to bring up said rights as existent, meaning the material part of your rights, the what of your rights. So, Articles point 1, aka 8.1, 9.1, 10.1, 11.1 is the material, the materiella, where you have the what, meaning it's the first step to admissibility, because if you aren't able to convince a court that you're admissible, aka your rights have been infringed within these parts, then there's no case. No right has actually been protected. You could almost call it anarchy. You probably shouldn't, but just to think of it as a more loose and fun way of understanding how states sort of uphold rights, just look at it as if the state hasn't put any laws in, then you've pretty much got a case of doing whatever the hell you want. Now, that doesn't mean that it's always going to be that way. People who are familiar with Söderman v. Sweden, for instance, or the case of the girl I explained in her earlier video, she was enslaved in France. It was a very special case of a tourist visa being ending up with a said person with a tourist visa at the age of 15 being enslaved, working like 12 to 15 hour shifts a day for several years. In that case, France didn't have any laws about this. They obviously changed that later, and the Convention of Rights had to correct it, but pretty much it wasn't existent, therefore this girl wasn't protected. That's sort of what the articles 8 to 11 of their point 1 is sort of going through. It's going through the things that are actually protectable. Step 2, look at the requirements for application. If admission is okay, did the state have the right limitation in the convention rights? Now you just move on to point 2, right? So the first steps, step 1, look at point 1 of the article. Step 2, look at point 2. Pretty simple. If you can't find anything in point 2, just like with point 1, then there's nothing there. That means that the state, in the second step of looking into this case, has realized that a limitation cannot happen. Or that it can. But all these questions in step 1 and 2 are material, aka what? Moving on to step 3, if it was in accordance with the convention, was it then also supported by native law or some EU law, going back to the principle of legality, or in Swedish, legalitetsprincipen, i RF 1.1. Sista meningen? Kanske? Anyways, it's pretty much asking the question of predictability. If there isn't a law which actually protects or limits rights, then it can't be applicable. Even if the convention has put in the idea, because remember, the convention is very general. We could argue pretty easily that the convention, in its general terms, protects rights that technically haven't been infringed on. If anyone is familiar with phonetic sounds, so the sounds that we're able to make with our mouth, like the O, A, S, T, there's a graph where you can look at the possible sounds you could make by like a metric system, and we haven't used all of them, right? You can look at it in that way, where most things, when put in conceptually, usually looks into ideas which haven't actually happened, but it's still within scope. That's sort of what the convention did with Söderman v. Sweden, and the case of the girl from, it was her versus France. I can't remember her name. I feel horrible. But yes, it's just a case of then the convention sometimes does protect rights, but then the state itself hasn't actually put in laws. And remember, a state, excluding then their constitutional laws, has to be very specific or more specific. So when you look at the first 2 steps of looking at Article 8 to 11, that's just the convention, right? That's outside of your own nation. However, when you get on to step 3, that's when you're supposed to look at your own country. So let's say anyone watching this right now, it doesn't matter where you're from, but if you are a lawyer or a jurist within the ECHR or ECHR, that means that the first 2 steps, you'll be able to look at it through any nation, just as a starting off point. But then when you move deeper into 3 and 4, you have to have knowledge of your own nation's rules. So this is also where generality of law comes in handy. A state gets to decide how they manifest these limitations of rights, or also these upholdings of rights. So step 3 goes into both point 1 and point 2 of each article. So both the material, meaning the what of the right, but also the limitation of the right. Moving on. Also to remember, they can't be too flexible either. For instance, it's not okay if anyone's watched the video yet. I'm hoping people are watching this chronologically, or at least eventually they watch all of the articles I made videos on. But pretty much in the right to a fair trial, you need to ensure that the laws that are written aren't so general that they, for instance, are anecdotes. Now, a famous anecdote could be like the snake and the frog that have to get over the lake. And then you have the frog helping the snake convincing the frog that why would I kill you if you help me over the lake, then we'd both die. But then at the end, the snake sort of killed the frog and said, I'm sorry, it's in my nature. That's an example of a very efficient way of anecdotally adding laws which could, for instance, speak to culture, right? Saying the snake is innately evil or innately damaging, even within the scope of their own health being obstructed. That is a highly dangerous way of writing law. I'm sure that dictatorships have these type of laws. I'm sure, I don't want to say specific nations, but I'm sure people could find nations which are definitely not democratic, but also have anecdotal laws. Moving on, step 4. I'm also going just to add, I know that religion is highly anecdotal. That's why the convention bans religious states. For instance, Iran, they have a religious state of Sharia law, right? And they had a case with Turkey where they tried to ban with Article 11 the organization of a Sharia. I forget the separations of pauses between vocals, but I know that I said Sharia incorrectly. However, moving on, they pretty much say anecdotal reasoning cannot be a way of upholding law. And it goes in right into the idea of then, for instance, organizations let's say in the case of Turkey then, being about Sharia law, those organizations can be banned immediately because the concept in itself doesn't protect the right to being a group, because the group, or being an organization or demonstrators, because, well, your concept in itself is damaging to the standards of a democratic society. Moving on. Step 4. Margin of appreciation comes in. What can be deemed necessary can depend on what situation is being handled and from what historical, economical, gender, age, and other factors, which got to determine what is necessary. This is probably where the margin of appreciation becomes super duper strong. So if it was not in accordance, then it has broken the convention rights. Meaning, going back to step 3, I should add this, sorry for the messiness. Going back to step 3, if we can confirm, meaning in the case of if we are the court of the convention, if we can confirm that the law is general enough, but not too general, right? Going back to the anecdote part, then we move on to step 4. And step 4 is about if it was necessary. You could go into the proportionality as well. But margin of appreciation becomes very strong at this point. Now, it could have its effect in all steps, both directly and indirectly, but step 4 is a very, very direct example of margin of appreciation. And then, just keep in mind or observe, this is a super generalized explanation. Do not forget that everything about these guidelines are dependent on the one applying it. Also understands margin of appreciation, convention, court's tendencies, court law, meaning it's arbitrarily selectable. It is. It shouldn't be, from like a state stances of rights and the rule of law. The EU doesn't do this. Your nation won't do this. But in the case of the convention, if anyone's watched my introductory videos, knows that the case laws in the convention is pretty bad. And therefore, I would say arbitrary in its function. However, still usable. But it totally depends on each nation. And it doesn't really follow logic by that sense because it's more historical, it's more contemporary and political. And usually those things aren't that objective. It doesn't have to be, but it just isn't in this case. Even though arbitrary may sound bad, it technically isn't. It's a very functional way of existing as a court. Moving on, historical and contemporary understanding and positive or negative obligations. So, yeah. And then going back to what I said with the convention court's tendencies, that's just a way of explaining. You're going to see in the later videos or any videos you've seen before. But in all of my videos looking through each article, usually it does come up of what the court sort of likes to do, like their tendencies. For instance, with the right to a fair trial, the court has a tendency there to limit the need to scrutinize national courts. However, if you have a specialized court, for instance, Sweden has a court for workers, Arbetsdomstolen, that type of court. Now, I'm sure that the convention by this point, from the Swedish perspective, does have a good idea of how that court works. I've met people within these courts. They're very reliable. They work very well. However, let's say in the case of probably in the beginning of when Sweden joined, there was probably not as much knowledge about the specialized courts of Arbetsdomstolen, meaning the court for workers. And then I'm sure, let's say the convention before before letting Sweden join, they probably had already established knowledge about the national courts. But maybe then, as the nation had joined, meaning Sweden, maybe a case came up, for instance, as it has with Arbetsdomstolen, was the case of a midwife. The court might have had to say, like, for instance, okay, we don't have as much contact with these courts, so we'll have to take our own initiative of understanding how they work, just as a sort of presumption of needing to, as a quasi-national court or quasi-constitution, meaning the convention, they need to take the responsibility of making sure that each case being taken into account has the proper ideas intact. Meaning information in itself, its validity of truth, should be the last thing that sort of is thought of. That's just the starting off point, no? It's also why a lot of cases, except for Article 2 to 3, the court usually accepts the circumstances of how a national court has investigated and found the case to have happened. Usually the court doesn't look into the facts, it looks into how these facts affect the law, right? People misinterpret that. That's a very common mistake from people who aren't actually studying law. You can, but it's very hard to convince a court that, especially then the convention's court, that information is invalid. Now I know in Sweden, maybe other countries it's not the same, but I'm sure it is. If you go to a higher instance of a court, you can't argue that the lower ones were incorrect, not as easily at least. You would need to have proper evidence. So the presumption always lies in the court being truthful in how they gather information and how they then take the material they've been given of facts and how they apply them into the law. But yeah, thank you for watching.